Dear learner, again you are welcome on this SWAYAM platform where we are dealing with the course Understanding Competition Law, Theory and Practice. I am your instructor and we are moving towards the third session of this seventh module, and today we will discuss the threshold for combination under this act within the meaning of combination. What is the threshold limit? If you remember in last class, what we have discussed, the transaction, which is the nature of transaction for the purpose of combination. We are dealing in this particular module with the meaning of the combination and regulation of the combination, that is regulation of merger and acquisition in this act, where we have established, that means we have discussed the any enterprise which takes into the activity like merger, acquisition or amalgamation, they have to notify it to the CCI if it crosses the threshold limit, and the threshold limit is a limit which is prescribed by the act and may be revised by the ministry time to time. So for that purpose, the two important aspects which is required for the purpose of the analysis, whether the transaction comes within the meaning of combination or not, and if the transaction comes within the meaning of the combination, then what is this threshold limit and what happened the threshold value if the combination is crossed with such threshold value. So that means what we have discussed in last two lectures, that there are two type element or particular two element which is very important to describe such issues, and the issues are first the nature of transaction, and the second is the transaction of the nature is comes within the meaning of the combination than the threshold value. In last session, we have discussed with the nature of transaction, which covers the meaning of acquisition, amalgamation, merger and this type of the activities. Now, in this session, we will discuss the threshold for the combination under the act to identify the meaning of the threshold limit, the threshold value and the prescribed value, because the thing is, if that combination crosses this threshold limit, then the CCI may took into the appropriate legal action under this act. So for that purpose, if you look at some introductory aspect of this, India is one of the fast growing economics in the world, and the growth process is driven both by organic and inorganic. It is neither feasible nor advisable to review all the merger and acquisition. It is natural to presume that in the case of a small size combination, there is less likelihood to appreciable adverse effect on the competition in market in India. The act provides for sufficiently high threshold in terms of asset turnover or mandatory notification of the commission. The act also provides for revision of the threshold limit every 2 years by the government. So in consultation with the commission through notification based on the changes in wholesome price index or fluctuation in exchange rate of the rupees to the foreign currency. These are only the factor on the basis the notification may becomes, or the ministry may revise the position or revise the limit which were what we are telling as the threshold limit for the purpose of the scrutinize or scrutining by the CCI to such combination. So what is the merger control threshold? What is the value? What is the threshold where the important, that is where is it, that is like the barrier you may not cross threshold. If you are crossing the threshold, the CCI will scrutinize it. And the threshold limits are the criteria. It is a criteria that will trigger a merger filing in the India related to which is either in case of turnover or assets. That means there are two things. First, acquirer and the target, that is individual parties, or the group to which the merged entity will belong after the acquisition of the group. That means for the purpose of control threshold limit, both is important. The individual enterprise or person or party or group. For both purpose, there is a threshold limit at the different level, and the threshold limit, if you see, what we have also discussed, that is a prescribed limit under this act, but that act does not prescribe any uniform or threshold limit. It only enable the government and government may revise such threshold limit generally in 2 years. That is based on some specific factors what we have discussed. So, if you see the recent data, the Ministry of Corporate Affairs revised the threshold limit for combination under Section 5 of the Act. And what is that limit? You may see in this slide at the two level. First, at enterprise or individual level threshold, and second, the group level threshold category. So, at the enterprise or individual level, the category is in two parts. First, what is the threshold limit within India and what is the threshold limit outside India. What is the threshold limit in form of or in terms of assets, or what is the threshold limit in the terms of turnover. So, in this category you may see if any combination took place in India and the asset is more than, not less than 2,500 crore and the turnover is not less than 7,500 crore. And if these combination took outside India within Indian presence, so the limit is $1.25 billion, that is 1,250 crore in Indian rupees, or 3.7 billion, that is not less than or equal to 3,750 crore in India. This is for the enterprise level only. Suppose if there are the group of enterprises, that means if there is a group where so many enterprises involved in forming a group for that purpose, in that case the threshold limit is exceeded. So that for that purpose, in the case of India, if there is a involvement of group, the assets not less than 10,000 crore and the turnover not less than 30,000 crore. And if it took outside India, that means the combination merger amalgamation between the group, if the asset is not less than 5 billion, that is equal to 1,250 crore rupees in Indian rupees, or if the turnover is not $15 million, that is not less than 3,750 crore rupees in India. So, this is the threshold limit, and mind it, this is not a uniform. This may be notified time to time and may be revised. And what we are discussing, this is the latest available as per the 2025, which is available on the data on the website of the Ministry of Corporate Affairs. This is of the 2024, in fact, this is revised in August or September 24. You may refer to the website of the Government of India. So, what we are looking, if you looking the slide, you may found that one that is on enterprise level and second that is on group level. So, if you see again in India, assets is not more than 2,500 crore and turnover is not more than 7,500 crore. If any enterprises level threshold limit for outside India more than 1.25 billion with the at least 1,250 crore in India and turnover more than 3.75 billion, which at least 3,750 crore in India. And group level threshold in India is more than 10,000 crore and outside India is 5 billion crore. Now, the thing is, some additional thing which is important, and additionally a new deal value threshold been introduced. That is introduced by the Ministry of Corporate Affairs, and recently the requiring notification for deal value 2,000 crore where the target has substantially business operation in India. The criteria for substantial business operating includes digital service and non-digital service, and if it digital service 10% or more of the global user base in India, 10% or more of the global turnover generated in India, and non-digital service 10% or more of the global turnover generated in India with an Indian turnover exceeding 500 crore and 10% of more the global cross merchandise values generated in India exceeding rupees 500 crore. Here the term group is become important. What we are discussing is in the case of enterprise, individual or group, what a group means. Group generally means the association or the togetherness of more than two or more than two persons, and that is in the case of enterprise. But you cannot take it as a generic term or literal term. because the term group is defined under the section 5, not defined, but that is the explained within the explanation clause of section 5. Under section 5 of the Competition Act 2002 in India, a group is defined in the context of combination, acquisition, merger or amalgamation to determine whether a transaction exceeds the financial threshold requiring approval from the Competition Commission of India. The definition of group is provided in explanation B of section 5, and it outlines the entity that are considered part of group for the purpose of assessing assets and turnover threshold at the group level. If you see the explanation B of the section 5, which states that group means two or more enterprises which directly or indirectly are in position to exercise 26% of more the voting rights in the other enterprise, or appoint more than 55% of the member of the board of director in the other enterprise, control the management of affair of the other enterprise. Just see a scenario for the purpose of illustration, and you may understand with this scenario, with this example, the better way. Suppose a company is acquiring a company B, and CCI need to determine if the transaction qualify as a combination under section 5. Now, company A is a part of larger corporate structure, and CCI evaluate whether the group exists. Now, the facts are, this limited fact I have given here just for the understanding as a hypothetical scenario. Suppose company A hold 30% of the voting share in company C, a subsidiary. Company A also has the right to appoint 60% of board member of company D. Company A indirectly influences the strategic decision of company E through a subsidiary that controls E's management. Company C, D, E are not directly involved in the acquisition but linked to company A. So, whether the group definition of group or the explanation of group is applicable or not. So, you may apply the explanation which is given under the explanation B of section 5, and in the case of company we can understand in each company case. Let's company C. Since company A hold 30% voting right, and as per definition the existing, that is more than 26 is required. So 30% is more than 26%, that in this case company is a part of company's A group. In case of company D, if you see, since company A appoint 60% of board, and if you see the definition, that is the limit is if the more than 50%. So in this case company D is a part of group, and company E, in case of company E, since company A indirect controls company E's management, company E is also part of this group. And in case of company B, as the target company B's assets and turnover are considered at the enterprise level, but post acquisition it may also become part of group for future assessment. So the definition of group, rather that is explanation given under section 5B, is now become important to analyze whether the company who are or enterprises which are likely prima facie does not establish such type of the transaction. That means it is not like the transaction are involved or so huge. But if you apply the definition or the explanation, you find that there are the large transaction, there are a very huge infrastructure or the structure of the enterprises where number of the enterprises are connected with each other, and this is only the explanation by which you may assess all the company in one scenario. And with this become an important aspect to assess for the purpose of the combination. Now, in this scenario, what we are taking as an illustration, if you see how CCI will evaluate. The CCI aggregate the assets and turnover of company A, company C, company D and company E to check if they exceed the group level threshold, which is as per the 2024, the latest is 10,000 crore or turnover is 30,000 crore in India. So, for the assessment of whether the combination took place between the enterprise have crossed the threshold limit or not, the definition or the explanation of group become important, where CCI applied the explanation B of section 5 and found that the companies are actually the part of the one enterprises and the transaction limit is if they aggregate or take aggregate in a number and the sum of rupees, it found that if it crosses the limit which is the prescribed limit, it may comes within the under the scrutiny of the CCI's eyes. So, suppose the combined asset of A, C, D and E in India are 12,000 crore. This exceed the group level threshold, triggering the CCI scrutiny even if company A and company B individually at enterprise or individual level fall below to the threshold limit. That is what is given is 2,500 crore, but individually they are below, but aggregate they crosses. So, the acquisition is combination under section 5 which requires CCI approval, as the group level threshold is met due to the inclusion of company C, D and E's company A's group. So, with this practical aspect, you can analyze how CCI will analyze and how CCI will act in such cases of combination. So, because we are dealing not only the theoretical aspects, that is why I am presenting this type of the illustration for your general understanding, where you may apply or you may assess the practical aspect as well. Let some example I have explored here just for the purpose of better understanding with the meaning of the threshold limits. And suppose you have to identify or you have to see or you will see how in this scenario or example the CCI approvals is required or not required. Suppose there is a company A having asset worth than 3,000 crore in India, merge with company B, asset worth 1,000 crore in India. The combined entity exceeded the asset threshold, that is 2,500 crore. That means it requires the CCI approval. Let another example. Suppose company X, that is global asset worth $1.5 billion with 1,500 crore in India, acquiring company Y, asset worth of rupees 500 crore in India. The combined entity exceed the asset threshold, that is 1.25 billion with not less than 1,250 crore in India, requiring CCI approval. One more example, company P, where deal value is 2,500 crore, acquire a target company with substantial business operation in India, that is in digital service 15% of user base in India and rupees 700 crore turnover in India. The deal exceeds the deal value, which is the threshold value is 2,000 crore rupees. That means in this case again the CCI approval is required. So, with these example, which is basically the illustration, the applicability of the revised threshold limit of combination under the Competition Act 2002. I am using the word revised threshold because I have explained you that the revision took place at the 2 years after, and in 24, that is in 2024, Ministry of Corporate Affairs has revised. So, with this you can see you have to analyze whether the combination is required for the purpose of the evaluation by the CCI or not. So, this become important. You have to know that there is a specific section, that is section 54 in the Competition Act. The Section 54 of the Competition Act 2002 empower the central government to exempt certain enterprises, practices or agreement from the Act's provision or a specific section thereof for a specific period. Such exemptions are granted in the interest of state security, public interest, international obligation for the enterprise performing sovereign action. So, you can see the key exemption notification under Section 54. Exemption under Section 54 are typically issued via notification published on official gazette and can apply to a specific sector, enterprises or transaction. I am giving some examples that are notable exemption with the emphasis on those affecting the Section 5 and Section 6, and up to the recent update what we are discussing to the March 2024. The minimum exemption, that is target exemption. If you see the notification 1131 of the 2024 of Corporate Affair, the exempt acquisition, merger and amalgamation under Section 5 if it target the asset exceeding Indian rupees in 450 crore or turnover not exceeding Indian rupees 1250 crore, and the validity for this exemption is till March 7, 2026, that is 2 years from the date of issue of notification. And the purpose is reduce the regulatory burden of the smaller transaction unlikely to cause significant anti-competitive effect. So, this was an enactment from the previous threshold. Previously, it was 350 crore. And the relevance of this section, it directly exempt disqualify combination from CCI notification, which is streamlining the minor details. So, exemption from group voting right is also by the notification of 2006 extended periodically for that, that means existing today, where the details of if the group exercising less than 50% voting right in another enterprise from being considered part of the same group for Section 5 for the purpose of Section 5 threshold, and extended in validity extended into 21, you may refer the detail from the website of Corporate Affairs or the government of the Ministry of Corporate Affairs, and this is for the purpose to ensure the minority stock with limited control not aggregate the group level threshold and reducing notifiable or notifiable transaction. So, with this, just see an example for this particular session. If suppose a company X hold 30% of voting right in company Y, that is below 50%, Y is not part of X group for calculating Section 5 threshold and potentially exempting a combination involving X. So, with this example, you may assess what is the exemption under this Act. So, for today's session, there are one self-assessment question for you. You have to go with this question to self-assess the particular session, and the question is, which of the following combination require prior approval from the Competition Commission of India under Section 5 for the Competition Act? Assume all values are for the financial year immediately preceding the proposed combination and no exemption apply unless stated, because we have also discussed the uniformity, there is no uniformity. So, you have to see this transaction is for a particular year or the current year or not, or if the transaction comes within the meaning of exemption or not. So, for that hint, I have already written here for you that this is of the immediately preceding proposed combination and there is no exemption clause is applicable. And the questions are the scenarios A, B, C and D. An acquisition where the target enterprise had asset of rupees 400 crore and turnover of Indian rupees 1100 crore in India. Whether the approval of CCI is required or not, just think over it. And the second is a merger between two companies with combined asset of 2000 crore and combined turnover of 6000 crore in India. And third one, an acquisition where the acquiring group has worldwide asset, this is worldwide, not domestic only, and you have to go to with the chart what we have analyzed before. 4 billion with 1,500 crore India and worldwide turnover of US dollar 10 billion. And the fourth one is the scenario, a merger where the merged entity or group has asset of 8,000 crore and turnover of 25,000 crore in India. So with this scenario, just think over it and try to find out which scenario is required the approval of CCI. So with this, I am leaving this session for today, and we'll meet in next session in this module to discuss the regulation of combination under section 6. So for today, thank you very much.